Right, let's get cracking. It's now 7 minutes past 8. So just a little bit of housekeeping to start the morning. Everyone is, well, first of all, hi everyone, thank you so much for joining us. This is the presentation or the webinar we wanted to do at the end of last month, and then a couple of gremlins slipped in and we couldn't do it. And so thank you for bearing with us and joining again today. I think it's going to be a very, very interesting discussion, and yeah, and hopefully you'll get a lot of benefit from it. With regards to housekeeping, as I said, everyone's cameras are switched off and everyone is on mute at the moment, except for our guest speakers and myself. And during our presentation, that it's going to stay the same. However, the Q&A will be enabled throughout. So if you have any questions that come up while we're speaking, please type it into the Q&A while it's fresh in your mind. And we will have, the intention is to have a half an hour of questions discussion at the end. So that is how we're planning on doing today. So please, if you have anything that you'd like to, or comments that you'd like to make, or experiences you'd like to share, please put it in the Q&A, and Andrea will assist us at the end to get to all of those questions. Just also a reminder that this is being recorded. So if there is anything that you would like to discuss or raise of a sensitive nature, I suggest you just pop me an email, and then we can get back to you privately if that is the case. But just to alert you to that as well. So that is it for the housekeeping. With regards to how we're going to be running this morning, we are going to have an hour of the presentation, hopefully, just to align you and get you to where we are and what the code says, and our views, or Haley's views. She's the expert on it. And then to hand over and to hear and answer any questions that there may be. We are hoping today for a more practical, we're not hoping, we are aiming for a more practical webinar today. So really to give you something to leave with that you can apply practically, rather than just telling you what the law is. Obviously, we are going to touch on the law, but more about how to implement it and how to ensure that you are sticking to the spirit of the law, and rather than just the letter of the law, because that is what the intention is. We're all passionate about productive and safe workplaces, and that really is the way to get there. So that's just a little bit of a summary for the day. Or the morning. We'd love to have you for a day because it's such a long, interesting topic. But so let me introduce our two guest speakers. We're very honored to have both of them, and thank you very much for giving up their time. Without further ado, let me introduce the two of them to you. Our first speaker is Haley Gilgert. For those of you who don't know Haley is an attorney with 20 plus years of experience, she specializes in sexual harassment, workplace discrimination, and chairing disciplinaries and investigations. She has extensive experience in providing legal guidance and support, evaluating and advising on the fairness of terminations of employment, and drafting and reviewing and updating workplace policies, procedures, codes of conduct, and employee handbooks. She has trained CCMA commissioners, case management officers, and translators in all CCMA offices nationwide regarding the handling of referrals dealing with sexual harassment. She has a wealth of experience in providing employment and discrimination law training and seminars that equip employers and employees with the relevant legal and procedural knowledge, as well as practical skills required to strengthen internal capacity and dealing appropriately with workplace challenges as they arise, which is the point of today's webinar. How do we deal with those? She has successfully litigated numerous high-profile precedent-setting employment law, discrimination, and gender-based violence-related cases in SA Labour Court, High Court, SCA, Supreme Court of Appeal, and the Con Court. And She has initiated ongoing and potentially precedent-setting cases relating to workplace discrimination on the basis of pregnancy, sex, gender, race, and disability. All right. She's also co-authored and presented numerous law reform submissions to the South African Law Reform Commission and parliamentary portfolio committees, lectured at several universities in SA and overseas, contributed to as well as supervised academic research projects, and been interviewed repeatedly by national and international media on a variety of discrimination and employment law related topics. Sure. So as you've heard, we've got an expert with us today. Very fortunate to deal with harassment, these issues, and obviously we're not just going to be dealing with sexual harassment, but harassment, and which obviously touches on discrimination as well. Then turning to our other guest speaker, who has a very different skill set, which is, I believe, going to be invaluable as well to our discussion this morning, is Nayette Atkinson. Nayette is a commercial mediator accredited by Conflict Dynamics and the Centre for Effective Dispute Resolution in the UK, with a background in advanced mediation from Fordham Law School, New York, and the UCT Business School in Cape Town. And before venturing into conflict resolution, Nayette accumulated 30 years of experience across the corporate sector, the NGO sector, and the education sector. Her rich and diverse background has equipped her with invaluable insights and experiences, enabling her to effectively relate to a wide range of people, cultures, and contexts during conflict resolution interventions. Nayette leverages her extensive executive level experience, financial acumen, and creative thinking to guide parties through mediations, facilitating their journey towards arriving at mutually satisfactory resolutions. In addition to mediating commercial, workplace, and community disputes, Nayette also offers workshops that focus on helping individuals, groups, and organizations to change their current patterns, beliefs, and behaviors. This is done by showing the participants how to use conflict as a tool of creating trust, understanding themselves and others better, eliminating negative behaviors, knee-jerk reactions, and fear. So those are our speakers today. Welcome very much to them. And thank you very much to them for their time and joining us. As I said, they are both very experienced, but in different areas. So I'm looking forward to engaging with them. Right, so this morning we're going to start off with Hayley. Hayley's going to set the background for us as to where and how harassment fits in with our employment laws. She's going to be speaking to the code that we're all familiar with regards to harassment in the workplace.
Hey,
Thanks,
good morning,
Hayley.
everybody. Good morning, Justine. Thank you so much for that generous introduction. All right, let's jump straight in. So the Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace was gazetted in 2022. The objective of the code is specifically to address the prevention, the elimination, and the management of all forms of harassment that pervade workplaces. So as Justine said, it's not just sexual harassment. And it repeals the 2005 code that specifically dealt with sexual harassment on its own. And the reason for this is not that sexual harassment has fallen off the table in terms of codes of good practice, but rather that the drafters wanted to have one place that deals with all forms of harassment, including sexual harassment, and that is this new 2022 code. So the code specifically recognizes workplace harassment on prohibited grounds as constituting unfair discrimination. And I'll speak a little bit more about the significance of the prohibited grounds in a few moments. Remembering that employers are under an obligation in terms of Section 60 of the Employment Equity Act, which is the act in terms of which this specific code has been gazetted, to eliminate conduct that would constitute a contravention of that act, which conduct obviously includes discrimination and thus harassment on a prohibited ground. The code provides guidance, and it's actually quite specific guidance on workplace policies and practices, as well as the appropriate procedures to deal with harassment and prevent its recurrence. Before we talk about what's actually understood as harassment, let's first look at who the code covers and where it's applicable. So although the code applies specifically to the working environment, it recognizes that the perpetrators of harassment, as well as those who are subjected to harassment, may include, but aren't limited to, quite a broad group of people. So it could be business owners, employers, employees, managers, supervisors, job seekers and job applicants, volunteers, persons who are on learnerships or interns and apprentices, clients, customers, suppliers, contractors, and basically anybody who has dealings with the business. Also, as to where it applies, in terms of protecting that group of people, or those involved with the business or associated with the business against harassment, it applies in any situation in which an employee is working or which is related to their work. And again, this is understood broadly to include, but not be limited to, the workplace, which itself includes public and private spaces in which people perform their work. So it's not just the employer's offices. It includes places where employees are paid, where they take rest breaks, meal breaks, where they use sanitary or washing or changing or breastfeeding or even medical facilities. It includes work-related trips and travel. It includes training, events, social activities, and importantly, also those that take place after hours. It also includes work-related communications by whatever means, so including WhatsApp, for example. Any employer provided accommodation or employer provided or controlled transports. And in the case of domestic and healthcare workers, it includes the residence of the person who pays them, as well as the residence where the care is provided. So it's a broad range of people that are covered, and it's also a broad range of places where it is recognized that harassment may in fact take place. Interestingly, in the case of persons who work virtually, which is more and more the case for many of us, it includes any location where they are working. So it could include a coffee shop, for example. All right, so now that we know who's recognized by the code as being the potential perpetrators or targets of harassment, as well as what constitutes a workplace, let's have a look at what the meaning of harassment is understood as being in terms of the code. So harassment is understood as being unwanted or unacceptable conduct, whether direct or indirect, whether persistent or even just a single incident, which impairs dignity. It creates a hostile and intimidating work environment for one or more employees, and it's calculated to, or it could have the effect of inducing submission by actual or threatened adverse consequences. And here again, really importantly, it needs to be related to one or more of the grounds in respect of which discrimination is prohibited in terms of Section 6 of the Employment Equity Act. And these grounds include a person's race, their gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, your conscience, belief, or political opinions, culture, language, birth, or any other arbitrary ground. So this definition raises a number of questions, including, what if the reason for the harassment does not have a discriminatory basis? What do we do then? Is it still harassment? Is it still something that as an employer we need to deal with? What if the harasser is simply a mean-spirited or nasty person, or someone in a position of power that genuinely believes that harshness garners better results from employees? So the issue in that situation is not that the conduct in question is discriminatory as required by the code to establish the existence of harassment in the workplace, but rather that there exists another form of misconduct on the part of the alleged perpetrator that still requires investigation and appropriate action from an employer. I mean, the bottom line is really that employees should not be spared consequences just because their harmful conduct does not constitute discrimination as defined by the Code or the Employment Equity Act. Intimidation, abusive position, bullying without a ground of discrimination underlying it is still misconduct and should attract disciplinary action and sanctions appropriate to the facts of the case, or mediation Either way, it needs to be dealt with. Similarly, that there is abusive conduct that is not based on a recognized ground of discrimination should equally not save an employer from liability if they have failed to eliminate it once it's come to their attention, because you're not providing a safe workspace for employees. All right, so noting that harassment is also recognized by the code as an abuse of power, the code further specifies that harassment can be the result of physical or verbal or psychological conduct. And it goes into quite detailed examples of each of those types of harassment, which I'm not going to go through now because they come up a little bit later when we deal with some of the specific forms of harassment. But they are in the code, and I would suggest that one goes and looks at them. What I would mention is that in addition to specifying that the conduct that constitutes harassment can be verbal or physical or psychological, the code also specifies that it can involve bullying, intimidation, mobbing, and include online harassment as well. All right, so now that we have a sense of what type of conduct may be harassment, how do we actually assess whether or not it is harassment in a specific situation that's brought to our attention? So the code provides that whether or not conduct constitutes harassment needs to be assessed on an objective basis from the perspective of the employee who alleges the harassment. Well, that's great, but what does that actually mean in practice? So what it means is that the objective test applied by the courts focuses not on what the alleged perpetrator intended. Intention is irrelevant to establishing harassment. Rather, it focuses on how a reasonable person in the complainant's position, or a reasonable person in South African society as well, depending on where in the code you're reading, would experience the conduct. And there may be circumstances in which the perceptions of the person alleging harassment are not consistent with the views of the reasonable person. And in such circumstances, the person who's accused or the employer charged with dealing with it may actually seek to establish that the complainant's perceptions are not consistent with societal values reflective of our constitutional order. And accordingly, after investigating, and I'm stressing the after investigating, you may be able to and wish to dismiss the complaint. Also importantly, while intention is irrelevant in establishing whether or not there has been harassment, one may still consider intention of the person who has been accused of committing acts of harassment after they have been found guilty of the offense of harassment in disciplinary proceedings, and one's looking at the appropriate sanction. And here the person who is chairing the disciplinary hearing, if there is one, would need to decide what weight they wish to apply to the intention of the person at the point when they consider sanction. And I say this because not all cases will be equal. Intention may be completely, that someone didn't intend to do something, may be completely irrelevant if what they did was very serious, or the harm or the impact thereof was very serious, or the reputational damage to the employer is very serious, or could be. And also bearing in mind that employers have an overarching duty to make sure that the workplace is safe for all employees and all who have contact with it, not just the individual complainant. All right, although many grounds of discrimination are recognized as being a potential basis for harassment, the code actually only goes into detail in relation to two of them. Firstly, in relation to sexual harassment, and secondly, in relation to racial harassment. But this is really not to say that harassment on the basis of any of the other listed grounds is to be taken any less seriously. I mean, in the last 25 years of specializing in this area, I have dealt with some very serious cases of disability-related harassment, religion-related harassment, and even pregnancy-related harassment. Also harassment dealing with political opinion and conscience and belief as well. And just in relation to disability-related harassment, I'm seeing more and more, I'm being requested to assist more and more with cases relating to harassment, disability-related harassment, where the disability relates to mental illness. And that seems to be coming up more and more in workplaces. So just something to note. All right, it may also sometimes be the case that employees experience genuine attempts on the part of employers at training or at skills transfer, or even separately, poor performance management as discrimination and harassment. This presents a really particular kind of challenge, and one that's often hard to navigate for employers, because it calls not only for really clear workplace policies and procedures to be in place before this can come up, but also for employees to be aware of and to understand them. It's not good enough to simply have an employment contract that incorporates all of the employer's policies by virtue of the contract, into the contract and as contractual terms. You can't, and you also can't just say that it's on the intranet and employees needed to go and read it. You actually need to communicate these policies and procedures effectively to your employees. And the same goes for policies and procedures relating to harassment. In addition to having the policies and procedures in place and for them to have been effectively communicated, there also needs to be clear communication between employers and employees to avoid misperceptions of harassment, or at least to try and avoid such misperceptions. All right, Justine, I don't know if you want to come in there before I move on to looking at the two forms of harassment that the code deals with in more detail.
I want to
go ahead, come in.
So no, it was interesting because when I was doing my research, there's been an increase in reporting since the code, but there is still where the policies and procedures are not known. So that deters people from reporting. So it's good that you're mentioning that the employer is supposed to make sure that people know what's going on.
Yeah. Thank you, Nate. What I've dealt with recently was actually, I was called into a rather large company recently, and I found that in that particular company, they had taken seriously the requirement, which I'll talk about later, of providing training to all levels of employees and staff and independent contractors and interns. And they called it diversity and inclusion training, and everybody had undergone it, and everybody had some sense of what harassment included. But nobody had trained anybody on the actual workplace policies of what to do, and even more importantly, what not to do if harassment comes to the attention of somebody in line management. And when it did come up, unfortunately, they dealt with it extremely badly because nobody knew what to do. So it's incredibly important that that happens. And more than that, I would say that it's also incredibly important that whoever is brought in to do that training is someone who specializes in sexual harassment law. And I'm distinguishing the training of what to do and what not to do from the training that Naet specializes in, for example. And I'd say that actually it would be great to combine the two, and it would be probably more effective to combine the two. But I do believe that in relation to the what to do and what not to do from a technical legal perspective, it should be not just any lawyer, but actually a lawyer who specializes in harassment law, has experience in dealing with these cases, so that you can be guided through what the courts have found in other workplaces, in cases that have actually been litigated, what's been acceptable, what's not been acceptable, what is considered adequate in terms of employer conduct once sexual harassment comes up, and how can you limit or avoid liability in those situations.
Can I just come in? Sorry.
Yeah, please.
From just to takeaways from the first portion of what you have mentioned, for me, just important for everyone on the call to understand, in summary, that the code that we're speaking about falls under the Employment Equity Act, right? It's there. And the Employment Equity Act says that harassment is a form of unfair discrimination. And in order for there to be unfair discrimination, it needs to be either on a listed ground or an arbitrary ground.
Yeah.
So that's where the link comes in. So that's why we're speaking about discrimination and listed and unlisted and arbitrary grounds. And Haley makes a very important point that just because it may not constitute harassment in terms of the code does not mean that it doesn't constitute something else that you should be dealing with. Whether you deal with it through misconduct, through disciplinary processes, whether you deal with it through a mediation between parties so that they are more comfortable with each other, whether you do it through training. But if someone is alleging harassment, just because it doesn't constitute harassment in terms of the code or the Employment Equity Act, doesn't mean that one just ignores it. Because it could be something else that you need to still action from a disciplinary point of view, or because dealing with it is going to make improve your workplace culture, your productivity, and relations within the workplace. So I just wanted to point that out, because often I know in practice, and not being a specialist in this area, but knowing a fair amount in this area, those are questions that we are receiving often. So it's just important to bear that in mind. So if there is this raised with you, just establish what is actually, and as Haley said, investigation is very important. Establish exactly what it is that is underlying this, whether it is harassment in terms of the Employment Equity Act and the code, or whether it's something else. And if it is that something else, how do we deal with that?
Absolutely. Thank you. All right, so now turning to the forms of harassment in respect of which the code provides greater guidance. So let's look first at racial harassment. So according to the code, or in terms of the code, racial harassment is obviously a form of unfair discrimination prohibited by Section 6.1 of the Employment Equity Act, and it's related to a person's membership or presumed membership of a group identified by one or more of the listed prohibited grounds or characteristic associated with such group. Again, it's to be assessed objectively with reference here to the reaction of, and the code says, a normal or reasonable person in keeping with the values underlying a constitutional order or our constitutional order, with explicit racial conduct being assumed to be unwanted. Also, in establishing whether language is racist, one would assess whether such language is reasonably capable of conveying a racist message to the reasonable hearer. While I didn't go through the specifics of examples of behavior that would constitute harassment under the initial kind of global definition of harassment in the code, I am going to go through it in relation to racial harassment, because I have been receiving more and more queries and requests for assistance in relation to racial harassment in the last few years. So racial harassment is understood as including abusive language and racist jokes, remarks, innuendos, cartoons or memes, name-calling or communications that amount to hate speech. It also includes racially offensive written or visual material, including online harassment, racist name-calling, and also negative stereotyping, impacting on a person's dignity. It includes offensive behavior in the form of open hostility to a person of a specific racial or ethnic group and offensive gestures. And it can also include subtle or blatant exclusion from workplace interaction or activities or even workflow and other forms of marginalization in the workplace. And obviously also threatening behavior which intimidates a person or creates a hostile environment. So often I receive queries that relate less to the more obvious examples of racial harassment and more to the ones that can be harder. One feels them, that one may struggle at times to prove them. And here employers really need to hear and investigate deeply and genuinely and introspectively in terms of workplace culture as well, especially around ones that involve negative stereotyping and exclusion, which can often be subtle, but have a huge impact, even on one incident, but certainly over time as a pattern of behavior and exclusion or marginalization within a workplace. Okay, moving on to sexual harassment. So sexual harassment is defined obviously as a form of unfair discrimination, this time based on sex, gender, or sexual orientation. And Justine knows that I have a lot of bugbears with this particular code and the way in which it's been drafted, and the test for sexual harassment really bears that out in terms of it being unfortunately very wordy and criticized as being quite confusing. So I'm going to distill it. Essentially, the test for sexual harassment, or the definition of sexual harassment, can be summarized as unwelcome or unacceptable conduct of a sexual nature, whether direct or indirect, persistent, or a single incident, where the perpetrator knows or, importantly, ought to have known that such conduct is unwelcome or unacceptable, with the code recognizing further that it violates the rights of employees and it constitutes a barrier. Sexual harassment constitutes a barrier to equality in the workplace. All right. In relation to the unwantedness of the conduct, the code makes a number of really important clarifications, they're all things that I stress deeply as being vitally important when I provide sexual harassment training. So the first is that there are different ways to indicate that conduct is unwelcome. You can indicate unwelcomeness by simply not responding, or turning away, or turning sideways, or walking away without saying a word. In other words, non-verbal refusals to engage are also indications of unwelcomeness. And that someone subject to sexual harassment doesn't need to verbalize their unwelcomeness at all. Often employers say to me, or people, if I'm approached by someone who's been accused of sexual harassment, and they say to me, but the person never indicated their unwelcomeness or the unwelcomeness. And you look a little deeper and you go, well, did they respond positively? Did they actively engage? Did they look a little uncomfortable? Did they, turn away, try and avoid you? Whatever it may be. It's not as simple as needing to say out loud, that is unwelcome, or that makes me feel uncomfortable, or please stop. An employee who is a subject of sexual harassment does not need to do that. Secondly, the code also recognizes that previous consensual sexual conduct does not mean that the conduct continues to be wanted. One may flirt, you may have an office flirtation, you may engage in an office affair, but if at some point that flirtation crosses the line, whatever the line may be, and you are no longer comfortable, or the person subject to it is no longer comfortable, or an affair ends, and one person really does believe that it has ended, anything that happens after that point constitutes sexual harassment. Thirdly, a complainant may seek assistance to communicate that the conduct is unwanted. In the same large organization that I recently spent time in, line management and supervisors repeatedly told me how in that particular case, young women who were interns and on learnerships had come and told them stories of a particular person with longevity of service, sexually harassing them and indeed sexually assaulting them. And the comments that these supervisors made were, I got tired of them complaining to me. It used to really irritate me that they came and complained. I used to tell them to go back to him and tell him themselves that they didn't like it and he must stop. And this was exactly the wrong thing for those supervisors to have done. In being told the stories of what was happening to these young interns, it was a report. A report was being made to somebody in line management, to a supervisor, at which point the employer's duties to investigate and take action kicked in. They should never have been sent back to the person who was sexually harassing and sexually assaulting them to verbalize repeatedly that it was unwanted and please stop. Fourthly, the code also makes it clear that sexual harassment may have occurred even where a complainant has not overtly indicated that the conduct is unwanted, because certain behavior is just simply unacceptable in a workplace. All right, so in relation to the nature of the conduct, in addition to physical, verbal, and non-verbal conduct of a sexual nature, the code also recognizes that sexual harassment may take the form of sexual favoritism, people getting promoted or getting, particular workflows from submitting to sexual advances, or quid pro quo harassment. So you do something for me and I'll do something for you kind of harassment. In assessing whether sexual conduct constitutes an impairment of an employee's dignity, the code requires one to bear in mind the circumstances of the employee, the complainant, and the respective positions of the employee and the perpetrator in the workplace. Why? Why is this so? Well, what the code's trying to do here is essentially to acknowledge that perpetrators of sexual harassment are generally in some kind of position of power over the person being harassed. But this power could stem from a variety of sources. It could be their position in the organization, their age, their authority, their economic status, their nationality, race or color, their social origin or gender. It could also be other relevant circumstances, including the example that I've already spoken about, somebody who just has longevity of service, who's been there a long time. And so the person being harassed probably feels that nothing will happen to them because they've been there longer. Or it could be that they have a close relationship to those who are in power within the organization or influence with clients over workflow or contracts. The Employment Equity Act, and it's mentioned in the code as well, requires that any contravention of the act by the conduct of an employee be brought to the attention of the employer immediately. And immediately, what that means comes up a lot, not only in terms of clients asking for assistance of, do I have to deal with this? You know, it wasn't reported immediately, or what does immediately mean? But it also comes up a lot in case law. And the Labour Appeal Court has held that the word immediately must be interpreted not technically, but rather in light of the purpose of the provision, which is to ensure that instances of harassment are investigated and that steps are taken to ensure that they don't recur. In the Nsabo case, many years ago in the Labour courts, which dealt specifically with sexual harassment, the word immediately was held to mean as soon as is reasonably possible, bearing in mind the circumstances of the complainant. And this is incredibly important in harassment matters. Very often employers seek to do nothing because they say they had a cut-off time for when it should have been reported, and immediately means directly afterwards, or, you know, maybe within a couple of hours. And if it's any later than that, we're not dealing with it. It's too late. That is absolutely not the case. And it's not how the courts deal with it at all. Immediately may be, depending on the circumstances, a few hours, a few days, a few months, or even in some cases that I've dealt with, reasonably a few years. One really needs to look at the circumstances. And to be honest, what I would advise is that regardless of when sexual harassment is reported, an employer should investigate. That don't get mired in when it was reported. Rather investigate, because ultimately you still have a duty to all other employees and others who have dealings with the business to ensure that there is safety. Okay. Yes.
Can I just also come in here at the immediately?
Please do.
Yeah. So very often the immediately has to do with, when do I have enough courage?
Absolutely.
When do I feel so regardless of your circumstances and all those external things, when internally do I feel that I can actually deal with whatever the rest of this process looks like? And I think that is why it is so important that it isn't there isn't a cut-off date, because there's so many other factors that form part of this.
Absolutely, no, thank you so much for that. That is so true. And it actually raises something else. If you find that somebody is resigning and it feels like it's out of nowhere, again, try and investigate a little deeper, because sometimes people, or not sometimes, often people who are subject to harassment and where they feel that the employer is not likely to do anything about it, or they won't be protected, or they feel too vulnerable, resign rather than reporting. And that's something for employers to flag and deal with as well. Especially if you want to avoid liability for constructive dismissals as well. All right. So how should harassment be brought to the attention of the employer? I often get asked by employers if there's a need for a formal report. And there is a misconception amongst many employers that a formal report is what is required. That is not true. It is absolutely not true. It does not matter how harassment comes to the attention of anybody in line management, and it doesn't need to be senior line managers, it can be junior supervisors as well. Anybody in a supervisory or management position who has knowledge or suspects or hears through the grapevine that harassment may be occurring, leads to an obligation on the employer to investigate. And the code is very clear. It says that there needs to be an investigation, and investigations in relation to harassment have also formed the basis of case law, and particularly the labor appeal courts, where the fairness of an investigation into harassment was interrogated by the courts and found wanting in a particular seminal case on the issue. So even your investigation process needs to be fair, and it may well be then that you need to bring in somebody external, a lawyer or a consultant or whoever it may be, to conduct a procedurally and substantially fair investigation. So what is it that employers are required to do once harassment comes to their attention, however it comes to their attention? Employers are required to consult all the relevant parties, and the code uses the word consult, but it also in other places specifically requires that there be an investigation. It requires one to take the necessary steps to address the complaint, and specifically to ensure that the complaints are not ignored or trivialized, nor do those who are subject to harassment or who blow the whistle on it fear reprisals for having done so. So in other words, no adverse consequences should result from blowing the whistle on harassment or being the person subject to it who reports it. If harassment is established, employers are required to take the necessary steps to eliminate it. And here I just want to make a point about consulting with the complainant or the person who's allegedly been harassed. Consulting with that person is not only important to establish harassment itself, it is also vitally important to establish their needs arising from the harassment, their workplace needs, and then the extent to which you as an employer are able to reasonably accommodate them. Not all needs need to be reasonably accommodated, but they certainly need to be considered and, where possible, accommodated. So what would those needs include? So if someone's been subject to harassment, it may be that they need additional leave to deal with the trauma if it's something that's been serious or had a serious impact. The code specifies the possibility of granting additional sick leave. To me, that is deeply unfortunate because it's not just sick leave that might be needed, it's any leave. It doesn't matter what the heading of the leave is. If one is able to, and somebody has been traumatized by harassment and needs a bit of time, grant them paid leave. It's the decent and fair thing to do. It doesn't matter what heading of leave it comes under. Secondly, they may require counseling or some kind of alternative therapy. They may require time off to attend it, paid time off. They may require a transfer to a different team or department or site, or alternative working hours or flexi hours or shifts. Provided, and this is extremely important and also comes up in case law dealing with sexual harassment and harassment in general, provided that whatever you do with the complainant or the person subject to the sexual harassment, no adverse consequences result. So you cannot worsen the conditions of their service. For example, if the perpetrator is not going to be dismissed, for example, and the person who has been harassed no longer feels safe or comfortable working around them, and one of the options is to move one of them to a different site or different working hours, it is the perpetrator who should be moved unless the complainant asks to be. You need to investigate things like, will it cost the complainant more to get to another site? Will their working hours be longer because it will take them longer to get home? What is the impact on their family or, family responsibilities if they work different shifts or move somewhere else? Will there be any change to their pay or ability to work overtime or whatever else it may be? You need to look into all of those things to make sure that no adverse consequences result in whatever it is that you are doing in respect to the complainant. Also, in terms of the code, the code points out that if harassment results in an employee being ill for longer than 2 weeks, the employee may be entitled to claim illness benefits in terms of Section 20 of the Unemployment Insurance Act. I have to say that in 25 years, I have never had a client who's done that, but the code does provide for that possibility. All right, then what about taking action against alleged harassers? What is it that's required? So importantly, and really vitally importantly, notwithstanding the very broad list of people that the code recognizes can be the perpetrators or those subject to harassment, only the employer of the alleged harasser can take disciplinary action against that person. Where an alleged harasser is an employee, a failure on the part of an employer to take appropriate action may lead to vicarious liability in terms of Section 60 of the Employment Equity Act. But here it's also worth noting that although employers cannot be held vicariously liable for the actions of non-employees, even where the harassment is perpetrated by someone who's not one of your employees, an employer may still need to take appropriate action to ensure that a safe environment is created for their employees and for others dealing with the business. But how can you do that? And there are many ways in which employers can do this. You can do this by speaking with the alleged harasser or reporting it to their employer if there is one, letting them know that the conduct is unwanted and unacceptable. You could remove your employee from interacting further with the alleged harasser, or refusing to provide services to that person, or refusing to procure services from that person in the future. If it's a case of financing or sponsorships, you could stop those contracts. You could claim a breach of contract and end your relationship with that person, and thereby either prevent the alleged harasser from engaging further with your employees, or limiting, if not eliminating, the possibility of future harassment. The code also speaks to the requirement that employers have an attitude of zero tolerance towards harassment. And really importantly here, zero tolerance does not mean that all cases of harassment must definitely result in disciplinary proceedings being instituted or the dismissal of the perpetrator. It honestly does not mean that. What it means is that you take the allegations or the rumors seriously, that you investigate, and that you take appropriate or adequate action, depending on the circumstances of the matter. And the code here provides, if you are going to go a disciplinary route, or even before that in dealing with it, that, you could follow informal and formal procedures. It says that you should tell complainants that those options are available and let them choose what they want, but it's actually a misnomer because it's not their decision to make. They can indicate their preference, but ultimately it's the employer who needs to make the decision about whether to follow a formal or informal route and whether to institute disciplinary proceedings, regardless of what the complainant may want. Again, because your overarching duty is to ensure that there is a safe working environment for all employees, not just the specific person or persons who've been subject to the sexual harassment. And then in relation to disciplinary sanctions, as I said, if someone is found guilty of harassment, it's not the case that everyone needs to be dismissed. Just as in any other form of misconduct, there are a range of sanctions, from warnings to warnings plus training, to being moved, transferred, to being dismissed. It sounds like someone wants to come in.
No, sorry, it's me. No, what I wanted to is just loop back to what you said earlier in this discussion about intention, because in order for there to be a harassment, it doesn't revolve around the intention of the perpetrator, if we call them that. It's how that action was experienced by the complainant. But when it comes to deciding on your disciplinary sanction, that is where you look at the intention. And if there was intent, that's a seriously aggravating factor, depending on how that harassment affected the individual. But if I could just come in here and ask a very practical, and I know I always say there are no dumb questions, but sometimes one does feel like you're asking a dumb question, but I'm going to ask it. When it comes to disciplinary action, often, well, not of my experience with this is how the complainant feels and what they believe would be an appropriate sanction may be very different to what the employer can do in terms of the employment laws, because the employer is still held to the Labour Relations Act. So that's a limitation of risk on both sides, right? The employer has to limit vicarious liability risk and all of those things, but also maintaining a safe environment and also a productive, happy environment. At the same time, you can't dismiss people unless you've got unless a sanction of dismissal is going to be fair. So how do we deal, just thinking practically, how does one deal with a situation like that, where your complainant is, I'm the person who's been affected, and I believe this person should be dismissed, and that's justice. Whereas as an employer, you aren't in a position to dismiss, because if you do that, it's going to be taken up at the CCMA and it's going to be found to be unfair because the sanction's inappropriate. That's the first question I have. The second question I have is the follow-on to that. So now we have taken disciplinary action, whatever the case may be, and we have to deal with that sensitively, and that I appreciate, particularly when it comes to sexual harassment. All forms of harassment, but particularly sexual harassment. So as an employer, how do I deal with that now? How do I deal with how the complainant feels about it? Is there a practical way we can deal with it? But also the rest of the workplace. Maybe, I mean, you were speaking about instances where there's particularly maybe there's a long history of harassment that's just come to the fore because there's been an investigation and one person had the courage to speak up, and now everyone is now finding the courage to speak up. And it's never been dealt with before. How do you deal with that in the workplace while maintaining confidentiality? Or all the employees are now know what's been happening and are looking at the employer to now actively deal with something, but you have to be confidential in dealing with it. Sorry, that was a whole host of questions, but just the practical side of that.
Now, Ed, would
I'm
you
just
like
thinking,
to come
I
in
know
here?
the law, but practically for all of those who are on the call, maybe that would be useful.
Yeah, I think I do like to come in because it's something we often find is that the confidentiality, and then other people either might perceive as if nothing has happened. And then it's a little bit for me often like, what is your indignation to hold? It's not a team effort, this, except where lots of people then find the courage. But the whole thing of harassment, bullying, all of those things, it always has an impact on your workplace culture, especially if it's not dealt with or if it's not perceived to be dealt with to a certain extent. And I think that is what Heidi said about your sanction must be appropriate. It's also to caution people to not have a narrow view of what fairness is. And sometimes we have a narrow view because we don't actually understand the wider legal side of it, but also the wider implications on what Justine is saying about how this is still part of the employment law. What do we do about that? So it's just for me always to be aware as an employer, what is the ripple effect of whatever sanction you're taking, whatever it is you're doing, and then the narrow bit of what information makes sense for everybody to know and what information is absolutely confidential, and it stays like that. Justine, I've answered some of your questions. The rest I'm leaving to Hayley.
Well, sorry,
right,
let me add can I add another question before it goes to Hayley? Is the individual who's complained with any form of harassment, but also I would imagine particularly with sexual harassment, and Hayley, that you can come in on this, but how do they go back to work if everyone knows what's happened? And as an employer, is that your responsibility too? If you've dealt with the harassment and you've dealt with that, are you now responsible for how they feel after that if you've dealt with that? It may not be a legal question. It may be a question beyond that, but that's what I'm interested in, because I mean, I know what the law is, but I want to know the practical, like, how do we deal with that? Because there's so many, it sounds like there are quite a lot of pitfalls. Yes, employers need to act and need to do these things, but within that framework and respecting confidentiality, we're still dealing with humans, and we're dealing with one human being or maybe a few human beings who have to go back into a situation. And we're dealing with individuals who are curious about what's happened.
So in a way, the employer is responsible for the mental wellness. So you have to create a workspace that is conducive to a productive workforce and also like a happy workforce. I mean, you're not responsible for everything, and I think maybe that is part of what is the view on that. And then you're right, you can't, and that's where I come in. You can't stop the gossiping. You can't change the way, and part of what I call the informal backlash. You get the formal backlash, and that's very often negative. But the informal backlash also has the potential to be positive, where somebody is actually lauded for the fact that they had the courage, because it's a ripple effect as well. Very often one person speaks up, and then the other people get the courage to speak up. But there is the appreciation and acknowledgement of this person had courage, and therefore they need to be applauded for that in a way. But also there is a space where, and that's a difficult one because that's very nebulous, and how long does it take to be okay, and how long does it take for the gossip and the things to die down and we can get back to work and we can get productive? And what are the steps in between that is the joint responsibility of the workplace, but also when is the employee well enough to be able to say, this is what I need, and this is when I need more, or this is okay, I'm feeling okay now? Because it is exceptionally uncomfortable after not just the sexual harassment, although sexual harassment makes it worse, but after any of your harassment issues have been reported and dealt with and it's out in the open. It is very uncomfortable, and it takes a lot of courage and self-awareness to be able to walk back into your space and carry on. And that's why we see so many resignations.
Mm. Yeah, absolutely. I agree with everything that it has just said. I think, I mean, one of the things that I always advise, and something that's actually currently before the Labour Court in Cape Town in relation to a test case on sexual harassment, specifically deals with the employer's duties around consulting and a failure to do so. And one of the things in that particular case, but which comes up a lot for many employers, is often employers think they only need to consult with a complainant once to find out what happened and what they need. And what Naed has just really eloquently pointed out is that they may not be in a position to know what they need yet. Or they may not be okay enough to voice it at that point, or trusting enough to voice it. And employers should actually check in with people who've been subject to harassment more than once. I'm not saying it needs to be ongoing for 5 years, but certainly, you know, every few weeks or once a month for a couple of months, until the point at which the employee and the employer together agree that actually we can stop checking in with each other now, but there is an open door, and as an employer, if you need to come and speak to me about something or something changes, please come and do that. Because people's needs change as you move through, particularly trauma. If the harassment has resulted in trauma, as you move through stages of trauma and you deal with what has happened, your needs are going to change. And an employer will only know that if they care enough to check in. So I would deeply advise that. Justine, in relation to disjuncture between the wishes of an employee who's been subject to harassment and what they want to happen and what an employer wishes to do in relation thereto, I mean, that's about clear communication, and it's also about explaining to the complainants or persons who have been harassed what is possible, and sometimes why a certain course of action has been chosen, and that not all instances of harassment require disciplinary proceedings, and not all instances of harassment need to lead to dismissal. Again, I'm going to stress the employer has to provide a safe working environment for all employees. So if there is a concern that this behavior may be happening to someone else or may happen to someone else in the future, or evidence is a pattern of behavior, or it's simply something that that particular culture in that workplace will not tolerate, then dismissal is appropriate. Or if the impact was so severe, then dismissal is appropriate. But in other cases, it may be that the alleged harasser did something unacceptable, needs some training, won't do it again, and life can continue, particularly for minor instances of harassment. And again, what is minor needs to be assessed with reference to the reasonable person and the workplace culture as well. But that's about clear lines of communication. And ultimately, just as somebody who is dismissed for harassment may challenge the fairness of their dismissal, the substantive fairness of their dismissal, equally, a complainant or someone subject to harassment may also seek to challenge, an unfair labor practice or discrimination within the workplace if that's how they experience it. And they are welcome to do that. Obviously, an employer would try and avoid that. But ultimately, though, that is available to them if they want to, and they, depending on what the employer did, will depend on whether or not they succeed.
Okay, so if I can pose another question, then, just listening to what we've been saying here, is that at the end of the day, it's to establish, what am I dealing with? Is it harassment? Or is it something else? If it's something else, how do I deal with that? Because I need to deal with it either from a legal perspective or from a workplace culture productivity perspective. If it is harassment, what type of harassment what is it? But that would be part of your investigation. And then if I am going to, throughout the process, investigating, speaking to the complainant, and engaging them and finding out what their needs are and those reasonable accommodations or whatever the case may be, and I end up having to take disciplinary action, or that is what's called for, to bear in mind that that the employment laws still apply, and I still have to have, obviously, procedural fairness, but substantive fairness, which then goes to evidence and goes to fairness of sanction, appropriateness of sanction. And then from there, it doesn't end there. Then as an employer, you still then, yes, maybe your legal responsibility in terms of the LRA, and that ends there. But in terms of the code and Employment Equity Act and all of those other things, it continues. It continues to ensure that there is no further harassment, because as I understand it, from the blowback, while it can be positive and you can turn a potential negative into a positive, which I love the sound of that, but that could spark harassment, right? Because if those people I'm just thinking practically, the person who's spoken out has spoken out, we've acknowledged them as one should, that it's a courageous act, but the person who potentially has been dismissed or has received a final written warning, whatever the case may be, if they're still there, then there's that to manage, that relationship to manage, and how you manage that. If they are not there anymore, potentially they've got an employee group who left behind who may disagree with what you as the employer have done, and they may then take that out, whether it's intentionally or whether their behavior just constitutes harassment again, right? because it could potentially constitute harassment.
Absolutely. And it happens. I mean, again, it's before the Labour Court at the moment. It's in a particular case that's currently being heard. But absolutely, that does happen. And that's for the employer to step in and to stop that intimidation, to stop that bullying, to stop that harassment, because that too is a disciplinary offence.
I had a case exactly like that recently, and the person was dismissed. And because some of the people felt that it was unnecessary, it led to big factionism within the organization. And then, although it's not harassment, it's just factional, it's at a severe impact on the organizational culture. One of the things that's come up for me as we talk about the employer's duties afterwards is also mostly leadership, and mostly male leadership in my experience, we are not very comfortable with dealing with these issues, especially not sexual harassment. And so it's almost like people then revert to doing it 100% by the book, legally, and that's probably where they make some of the mistakes that Heidi's mentioning. And then there's that sense of, okay, I've now done that bit. That I'm now covered. I'm not, and it's the after the fact, those kind of things we need to get more comfortable with. After the fact is, well, how do you raise awareness in your organization that this is actually not the culture we want? How do you make sure that it stops? How do you make sure that the people know there's been enough communication so that everybody understands what's happened and why it's happened without breaching confidentiality, and that there's ongoing support? And I'm not sure if it's just going to be a sign of the times and people are going to get more comfortable with the issues around sexual harassment, or what we can do except educating companies and leadership about how to feel more comfortable about having conversations in the first place. The example you used about the people, the interns, saying that is such a clear example of, I don't want to deal with this, regardless of whether it's my job or not, or my position. I don't want to. And we see that more often than not, actually. And that's a pity, because in a way, where is your safe space then? So yeah, so your line manager is supposed to be your safe space, or your management is supposed to be your safe space. But if it's not actually making you feel safe, or if your experience is that it's not going to go anywhere, then what?
Yeah, no, absolutely. And in fact, the code does actually talk to that, and it does provide some guidance of what it feels that employers should do to try and deal with that, and also obviously to prevent sexual harassment. And you know, it's everything from making sure that there is a policy in place, or if you have a policy that's outdated, to make sure that those policies are amended. Having said that, where an employer doesn't have a harassment-related policy in place, its conduct will be measured against the provisions of this code. But I would still, suggest that policies are put in place and updated where they need to be. The code also, I'm sure you know this, specifically says that workplaces should, conduct independent assessments of the risk of harassment within their organization. And these can also be independent culture assessments to determine the extent to which the culture in the organization supports harmful practices, and what needs to be put in place to try and intervene and try and eliminate that, or shift the culture within a specific working environment. It also suggests that a safe person outside of management be designated to whom others can report harassment if they feel comfortable doing so. And, I read that and I'm always a little uncomfortable about that, because in certain workplaces that will work beautifully, and in others there just isn't a safe space. So regardless of who you appoint, I've often heard from employees that they don't regard HR, for example, to be a safe space, and they would never wish to report to anyone in HR. So who isn't a safe space? And as you've raised, is very workplace dependent and individual. it also says that you need to deal with anything that comes to your attention, however it comes to your attention, immediately. Don't let things fester. And, as Nate says, have those conversations. And, Justine, Naet, and I are all accredited mediators. And sometimes what is required isn't just, a mediation to try and resolve a dispute. Sometimes it's a facilitated conversation. And those facilitated conversations would also apply, in the aftermath, as Justine and Naet have been speaking to, in the aftermath of harassment being reported and the fallout within a particular workspace. Those facilitated conversations can be incredibly meaningful and important in bringing those in the workspace back together in a manner that is future-looking and productive, and where a culture of respect and safety with sound labor practices is actually entrenched, and where people can trust it and know that harmful behavior won't be tolerated in the workplace, and when it occurs, it will be dealt with appropriately.
Thanks. Sorry, Haley, to cut you off, but that's a nice little summary of where we've been and where we've come, because I see we pushed for time and we've promised everyone to release them at 9:30, and we have quite a few questions. But if I can once again just try and summarize that piece that we've spoken about now, it sounds to me as though the key to this, not that there's a simple, neat solution to all of this, but it is workplace culture and communication. Workplace culture, communication, and safety. That seems to be it. I mean, kind of in a very simple way. And I think it speaks to that case that you mentioned right at the start. And I know we keep speaking about sexual harassment because that's, in our society, it's quite prevalent. I mean, we've had the judiciary a couple of months ago. They've even got a code of conduct with regards to sexual harassment. So it's everywhere. But harassment in a complete, it could be racial harassment, and someone doesn't want to speak up in the workplace about that. But what you mentioned is that with that investigation you did, it wasn't the individual who spoke up, but it was her colleagues that spoke up on her behalf. And I think that is such a key takeaway for us today, is that to create an environment where that is going to be brought to the employer's attention. And where the colleagues feel safe to bring it up, but also feel a responsibility to their colleague to speak up where an individual is unable to speak up for whatever reason. Because if that's the case, and individuals are standing up for their colleagues and bringing it forward, if they're returning to that workplace, the chances are they're going to be returning to a workplace that is going to be more accepting and more accommodating, because they understand how important that is, protecting each other and ensuring a safe workspace. So that's my takeaway from this piece. And also, I know we've chatted about it privately, but the just on productivity in the workplace, the kind of impact that harassment has. If individuals are being harassed, it doesn't make sense not to deal with it. It's besides the vicarious liability, it's just going to affect productivity. It's people, if you're being harassed, you're not going to want to come to work.
Yeah.
You're not going to be there. When you're at work, you're not going to be focused on what you're doing. You're going to be looking over your shoulder, trying to protect yourself. It just doesn't make business sense if you just distill it to the rands and down to the rands and cents. So thank you very much for a very enlightening conversation, and we could carry on for hours and hours and hours. I know, because we've only scratched the surface, but we are limited in our time, and I know there are some questions. So Andrew, could you assist us just with those questions if you don't mind?
Yes. So I have one question that was received from Nicole, I believe. I'm just trying to view it, and then there were a few questions from Shamila as well.
And I think Klingile was trying to ask a question as well.
Okay. So I'll just go to the Q&A and then I'll go to the chat function. In the Q&A
Okay.
section, there were 2 questions from Shamila. Actually, a few questions, 3. She said that the one question was on that, Justine, Haley, and Nahed. How should companies respond when harassment occurs outside the physical workplace, such as on social media? Then she said Haley mentioned that the social media item earlier, or during remote work. So how should harassment or companies respond to harassment when it occurs outside the physical workplace, such as on social media or during remote work?
Okay. Do you want to give us the other 2 questions? Maybe they're related and we can deal with them.
Sure. Then she had a question for Nayet and Haley. She said,
Okay.
in terms of employer duties, after what other metrics or indicators can be used to assess whether a workplace is truly safe and inclusive, apart from the survey's equity metrics EAP? Then the
Okay.
other last question that she had was, on a broader context, how does SA's approach to workplace harassment compare to global standards?
Okay. All right. So shall we start with the first one? How do we deal with harassment on social media platforms?
Haley can do the first one, I'll do the second.
Okay. Okay, brilliant. There we go.
I mean, it would depend which social media platform, for example. But if is it the target of the harassment's personal social media platform? Is it the company social media platform? What the employer is able to do will depend on which social platform we're talking about. But so, for example, if it's through the public employer's social media platform, I would strongly suggest that the employer take down those posts immediately. I would secondly suggest that, if there was some reason why you wouldn't take the post down, that a very strong response be placed on the social media post, talking to the unacceptability of this and the inappropriateness, and you stand by your staff and you create that safe space for your employees. And then everything else that I've already said would follow. If it's someone outside of the organization, you consider your relationship with them, you report it to their employer if there is one, you take steps to protect and remove your own employees from contact with them if they're in danger of ongoing harassment. You would deal with it in the same way. Yeah, I see that there are some other questions, but I'm going to hold off because they haven't been raised publicly yet.
Okay, Nayet.
So in terms of how does South Africa rate against the rest of the world, our sexual harassment is a bit higher. Our sexual harassment is towards women in the workplace is at 30%. There is also sexual harassment against men, but that's quite a bit lower. And then other things like bullying and racial things, we're pretty in line with the rest of the world.
Sorry, is that occurrences, or is it how are we deal with it as in our policies and our laws?
It's occurrences, how we deal with it in our policies and our laws. We ahead of some countries, and in other countries they're even less tolerant. So if you take some of the Sweden, those countries, they are exceptionally strict. But those are occurrences. So in terms of occurrences, and I think occurrences also, so there's reported and awareness, and all of those things just become more apparent. And then the more there are, the better you start dealing with it as a society. The other question was about how do you know that your culture has shifted? And I think that's where the thing is, like, the law is the one thing, and then there's the personal bits of how people react and what they're comfortable with and their own personalities and things. The conversations that Haley mentioned about afterwards is probably one of the most effective ways in finding out if your culture has really shifted. So you do your questionnaires and your what the things that she mentioned, and then you give it about 6 weeks or something like that, and then you have a deep conversation with smaller groups and see what comes out, and then you can have a deeper conversation. A culture shift is not an overnight process. So you might be more aware and people might stop certain behaviors, and you need to, but how do we really know if we are have each other's back, will stand up for each other, absolutely not tolerate any behavior that might in any way constitute harassment. Conversations is what I found to be the most effective.
But then those are conversations that are, I'm just putting it out there, I imagine facilitated by someone who knows how to deal with these conversations, particularly if it's straight after an incident. Then I would imagine a conversation could go either way. Either it could turn it into a positive experience and start changing the shift in culture, or it could actually make the situation worse, right? Potentially. So someone who knows what they're doing and is trained to do that. And then further from the incident, if you're wanting to have discussions or to have workshops even, to check base or build relationships or whatever term you want to use, also useful to have someone who's trained in that, because then you really, and because it's an outside person, right? It's going to be more meaningful potentially if the business sees an independent person coming in and doing these assessments and speaking to it. Because A, it's independent, so the company can't hide anything if that's the kind of feeling. But two, oh, look, the organization is actually taking this seriously and they're bringing in someone who is a specialist in this or whatever the case may be to come and assist us and give us guidance.
Yeah, it's also about the person being independent and neutral and being able to create a safe space where perhaps internal staff are not able to.
And that's where mediation is quite useful too. I know we're all mediators, so we like introducing it. But that's so important, or a facilitated conversation. But mediation, because it is confidential. That's one of our pillars of mediation. It's confidential and it's without prejudice. And whether you have been brought in by the company or whoever, that is a safe space that is sacred, right?
I see that there's a really important,
Sorry, I'm not looking at questions. Yes.
There's a really important question from Kobus, which talks to something that I spoke to near the beginning of our conversation. Which is not to say that everybody else's questions aren't important. No. It's just that Kobus is the only one whose question I can see, firstly.
Okay.
But secondly, it is actually a really meaningful question. So thank you for that. How do you deal with reversed harassment from staff to management? And when the staff member is confronted, that's the first part, when they turn it around, when a staff member is confronted and they turn it around. So for example, the example I gave of a poor performance management, and then the person claims that they're being harassed when they're actually being poor performance managed. So there are a couple of things in there. And the first is that if let's deal with the poor performance. If an employer is confident that there is in fact poor performance and all of the things one needs to assess to establish poor performance and all of the things one needs to do to deal with it in a manner that is fair in terms of labor law are in place and are being done, then an employer on the poor performance management, as a lawyer, I would advise to stand your ground. If you've covered all your bases correctly and you've taken the correct advice and you are absolutely confident that what you are doing is fair and appropriate, then stand your ground regardless of any allegations of harassment. But in relation to the being turned around and the allegations of harassment, that is a perfect opportunity for a mediation or a facilitated conversation in relation to that, to see if that misperception or experience of what's happening can be shifted. And if not, then the employee would have an opportunity to take that further if they really wanted to, and to go to the bargaining council or the CCMA and try their luck there if it really is ill-founded. But again, if this is a relationship, well, I haven't said this before, so I can't say again, but if the relationship with a specific employee is one that you would want to continue, if this could be smoothed out, then a facilitated conversation or a mediation in relation to that would be really meaningful, and can really help in terms of preserving the relationship and making it better going forward, and more productive.
But also just touching on that, I mean, we have as attorneys, Nate, I don't know if you want to weigh in here too in your experience within your specialization, but it's not we see it regularly where someone is being counseled for poor performance or potentially facing disciplinary action for genuine reasons. And that is thrown up just to try and halt the process.
Yeah.
So once again, it's to assess it, whatever is being raised, assess it and what am I dealing with? And potentially if someone is raising either against management or against fellow employees, false claims, and you can show that it's false, that there's a malicious intent or whatever it is, that is misconduct. And one can take disciplinary action. So once again, what is it? And where do I stand on it? And what do I have and what can I do within the parameters of the Labour Relations Act or the Employment Equity Act? But I think also we've become, harassment and all of this is incredibly serious, particularly with productivity and vicarious liability and all of that. But at the same time, don't lose sight of the fact that it can still be used as don't just freak out when someone raises it and back off, because there is a genuine process in place. So I think it's a fine line. And once again, those facilitated discussions, potentially if it's a relationship that you genuinely want to preserve, those are very beneficial. So you've got a whole you've got a toolkit available to you. And you see, what am I dealing with and which of my tools are going to be most appropriate?
Justine, I think it's actually a very nice just checklist. What is it? Where do I stand on it? How do I deal with it within the legal parameters? And what do I need to do afterwards? Just whatever comes across your desk. So just for a bit of clarity.
Any other questions, Andrea, that we haven't dealt with? You mentioned Nicole. Nicole had a question or not?
No, I think it was removed, but I don't see any other questions here. It was just from Shamila and then Quibus. Let me just confirm in the chat function. Yep, it was just those two.
Perfect. So if ladies, if I can ask the two of you just for a closing, important takeaways for our participants today. If you could, if you could say, these are from today, if I could be with you, sitting with you, please just remember these things. Or any other pearls of wisdom that you would like to leave our participants with before we sign off?
I think for me, it is about awareness. So if your so that's why I like to start with a neutral kind of information session or workshop, because if your entire organization is aware of what is acceptable and what is not, then you already have a certain culture that you're trying to instill if it's not already there. The second thing is that it's very important that everybody understands that any issue of harassment will be taken seriously from management up and down, all those things. And the last thing is that not everything needs to lead to dismissal or disciplinary. There's a lot of room before you get there for a conversation, a facilitated conversation, because sometimes that just clears up so much, but it's also a better way of establishing a real change in behavior. That's the one.
Thanks, Nayet. Haley?
I think for me, I would simply just say, given how much I've spoken, that I think what we all want to do is create workplaces that are built on inclusion, trust, respect, and sound labor practices. And, it's that we need to focus on, and everything that we've discussed here today is really a guideline on how to do that, and in particular in relation to harassment, which, if it comes up, really does need to be dealt with and investigated and taken seriously.
Brilliant. Thank you. So then if I could just takeaways from my point, from my side with everyone, is possibly go back, review your policies on harassment. If you don't have a policy on harassment, look at getting that in place. And also there may be, you know, you however you want to deal with it. But if you're going to have a standard policy or a policy on harassment of all sorts, fair enough. But think about ancillary issues to that as well. What about relationships in the workplace? Are we going to have a policy about what is our culture? Do we allow relationships in the workplace? Do we not allow relationships in the workplace? Because those also open it themselves to other abuses potentially, or not abuses, risky situations, right? Because this is about managing risk and creating safe spaces. But at the same time, you want to strike a fair balance. You don't want to treat employees like children. So it really is to sit down and think about that. Do I have policies? If I don't have policies, I need to put them in place. If I do have policies, perhaps I should just review them and see whether they are consistent with the legal position, but also practical. Because it's a policy, if you're just going to have a policy that speaks to the law, potentially going to miss out all of the other stuff that we've chatted about today. And as you've heard, that is all very important. So let's think about that, the policy stuff. Then it's all very well having a policy, but if your employees don't know there's a policy and don't know how that policy applies, training. That's the next step. And then, as we've said, or as I've said, as I think all of our speakers have said in different forms as well, workplace culture, safety, communication. And how do I start working on that if I don't have it? If I have it, let me maybe do an assessment. Where am I on that? And if I can improve on it, how do I improve on it in an effective way? Because it's also, you can bring in all sorts of people to put up slides and do all sorts of things, but is that really going to address your needs? And how is it going to land with your staff? Because that's important. Matching whatever the training is, or the workshop, or the facilitation, or mediation, whatever the case is, once again, it's that toolbox. What do I want to achieve, and how am I going to do that? So if you want a checklist from today, I think those are, do I have policies? If I don't, get them. If I do have them, let's review them. Got them, train, and then also as part of that training, it flows onto workplace culture. And it's not just the Employment Equity Act. Remember, all of these other things tie in with our legislation. Occupational health and safety. You have to have a safe work environment for your employees, and that is a separate act, which also speaks to what we're talking about today. So there are all these little things that get pulled in, and as an employer, you are exposing yourself to huge risk, legal risk, but also risk from a productivity point of view, where you could be capitalizing and turning potential, as Nate said, potential negatives into positives. So I'll just be quiet now after all of that. And if anyone wants assistance with regards to their policies, their training, workshops, facilitated discussions, whatever the case may be, feel free to drop us an email, and I'll put you in touch with the person who'd be most appropriate for that, and we can take it from there, please. But thank you very much, everyone, for your time this morning. I hope it was useful. I hope we added to your understanding of what is required from employers, and also more than just the law, practical applications. And yeah, thank you very much. We really appreciate you coming to listen to us. And thank you for your questions. Those are always useful as well to guide us as to what you would like to hear us speak about, and also for us to know what's going on out there and where those pressure points are for clients and employers. This is being recorded, so it will be on our YouTube channel as well if you want to have a look at it again. But also, please feel free to reach out to me or to Shamila or Andrea if you have any requirements with regards to your policies or training or whatever the case may be, and we will then put you in touch and set up something with the right people to assist you. Thank you. And thank you, Nayet, and thank you very much, Haley, for your time and for the engaging conversation and the insights and the practical insights that you've given us. It's always nice to hear what's happening beyond just the law and the legal documents, which are living documents. So that's always great. And then with that, we'll be signing off. So thank you very much, everyone.
Thank you, everyone.
Bye-bye.
Bye.
Bye.